Hello, everyone. Thanks for joining us. This is our inaugural episode of the Public Law Parlour. This is the first time that we are actually doing this particular podcast. So this is the launch of the Public Law Parlour. Now, you may be asking yourself, what is the Public Law Parlour? And the Public Law Parlour is really a place for casual conversations about Caribbean public law and public law generally, whether it's Caribbean or international. And it is a podcast designed to make public law more exciting, more engaging, and accessible. The podcast is hosted by two public law enthusiasts. Myself being one of them. I am Rico with attorney at law from Barbados, and my co-host Alexander Ramdas, my good friend and my colleague from Trinidad and Tobago. So we're just two public law enthusiasts. We love to have casual conversations about public law every day, every week, and we decided why not make these discussions into a podcast. So we are finally here. And we're going to be discussing landmark cases, ideas, and principles that shape public law in the Caribbean and beyond. We will break down all of these things with clarity, with insight, and of course, a hint of Caribbean flavor. So if you've ever felt like public law was too complicated or too dry or too boring, this is the podcast that will certainly change your mind. Alex, do you have anything to say for the first time for our listeners and viewers?
Hi, everyone. I'm Alexander Ramdas, an attorney at law, practicing in Trinidad and Tobago. I'm very excited to start this podcast with my colleague and friend and many times intellectual rival, Rico, who throughout this podcast would pretend he's a simple man living a simple life. But that being said, I think it would be prudent for us just to segue into the topic of today's discussion, that being decolonizing justice, the Caribbean Court of Justice, and 5 cases that shaped Caribbean constitutionalism. Now, Rico has many facts to tell you about the Caribbean Court of Justice that he could do far better than me, so I'd let him go.
Right, so I'm not sure about many, just a few fun facts, guys, which most of the viewers and listeners, I suppose, would already know. So the first one, obviously, is that the CCJ was actually established in 2001 under and by the agreement establishing the Caribbean Court of Justice, but it was inaugurated, meaning it was officially opened in 2005. So from 2005 until now, the CCJ has been operating and it has been acting as not just a final court of appeal for certain Caribbean countries, but also an international tribunal where it actually has the compulsive authority and jurisdiction to deal with disputes stemming from the revised Treaty of Chaguaramas, which then leads me to the second fun fact, which is that the CCJ is such a unique court and is a unique, as I think former Chief Justice of Barbados, Sir David Simmons, put it. I think he called it a unique judicial institution of Caribbean creativity. And I would never forget that because that's perhaps the perfect way in which you could describe the CCJ. And we say this because the CCJ has dual jurisdiction. And like I said just now, it serves as a final court of appeal currently for 5 Caribbean countries. Those would be Barbados, Belize, Guyana, St. Lucia, and Dominica. And it serves as a final court of appeal for those countries in its appellate jurisdiction. That is the first jurisdiction. And then it has its original jurisdiction, which, like I just explained, it then serves as, I guess, the guardian of the revised Treaty of Chaguaramas, where it actually interprets and applies the revised Treaty of Chaguaramas and the provisions therein to disputes arising under that treaty. And I think the CCJ is perhaps the only court in the world that serves as an appellate court, a final appellate court, and also an international court simultaneously, which is why we say is a unique judicial institution. So, as my brother-in-law, and I say brother-in-law because we are brothers in the legal profession, um, as Alex just said, today we're going to, well, Alex has a very special and fancy theme for you guys. My theme is basic and simple, and we're looking at the CCJ's contribution to the development of Caribbean constitutional law, particularly in the human rights area. So before we delve into the 5 cases, Alex, which would show how the CCJ has been, as you put it, decolonizing public law in the Caribbean, is there anything else that you would want to add? Any other fun fact?
I think you are probably the only person in the Caribbean who finds facts about the CCJ's origin fun. But I think it would be a good time to go into the topic and why it's important.
Yes. I mean, before we do that, perhaps we could let the viewers and listeners know, Alex, that we are not just public law enthusiasts, but we're also CCJ enthusiasts. We are very proud and staunch champions of the Caribbean Court of Justice. Just have to put that out there. And even though Alex is from Trinidad, a country that is yet to make the Caribbean Court of Justice its final court of appeal, he is a proud champion of the Caribbean Court of Justice. So let us just put that out there for all our listeners and viewers. So it's not a coincidence or it's not accidental that we made this the inaugural episode of our podcast called the Public Law Parlour. And with that being said, and by the way, hopefully, Alex, hopefully your homeland accedes to the CCJ's appellate jurisdiction in short order. Hopefully, because I know it's still on the table over there, and you guys are now discussing it.
That is a conversation for probably an entire next podcast.
Yes, yeah.
But
yes.
Okay, so getting into today's topic, decolonizing justice and the Caribbean Court of Justice. We chose this topic particularly because it, at least to me, it merged or it reflected what Simeon McIntosh, who is a very famous constitutional scholar in the early days of Caribbean constitutional law, would have called the need for an autochthonous Caribbean jurisprudence. And what he meant by this was that when we received our constitutions in independence, at independence times, our constitutional law would have been written reflections of established principles of British constitutionalism. For context, the British Constitution is an unwritten constitution. McIntosh was very big on reclaiming constitutionalism and shaping it in a Caribbean perspective. And as the apex court for several Caribbean jurisdictions, and hopefully in the future, all Caribbean jurisdictions, the CCJ has not even slowly, but has taken this mandate by the horns, and in the last 20 years has begun a very targeted process, or has begun very directly to grapple with what it means to be a Caribbean constitution. And on many occasions has derogated, varied, or created new rules of constitutional interpretation or constitutional expression that are unique to Caribbean societies. And the 5 cases we have selected today are cases that we think speak to this reality or speak to this effort. So without further ado, case number 1, perhaps the most famous case in the CCJ's appellate jurisdiction, the Attorney General against Joseph and Boyce.
And not just the most famous case in the CCJ's appellate jurisdiction, Alex, but perhaps the most famous case in Caribbean constitutional law generally. You cannot be a Caribbean law student or a Caribbean lawyer and do not know about the case of Joseph and Boyce from Barbados. And I'm proud to say that Joseph and Boyce emanated from Barbados, like I just said, and I'm a Barbadian, and from the time it was decided, it was the most seminal constitutional law case in the Caribbean, and it still is, I dare say, the most seminal constitutional law case. So I mean, and this case, I think this was perhaps the first human rights case that the CCJ had to decide after it was inaugurated in 2005. Joseph and Boyce came on the heels of that inauguration in 2006.
Yep.
The court right off the bat, the court was about creating that jurisprudence with a Caribbean flavor where human rights is concerned. So back over to you, Alex. I just had to make that clear.
Okay, so I was hoping you, as the Bayesian in the room, would have given a brief summary on the facts of Joseph and Boyce. But as I said, Rico is the only person in the Caribbean who finds fun facts about the CCJ interesting. So you got some fun facts about the CCJ. So in summation, Joseph and Boyce dealt with a challenge, a constitutional challenge by Marlon Joseph and Lennox Boyce, who were two persons convicted of murder and were sentenced to death. Essentially, what they challenged was the decision to issue warrants of execution while they still had petitions before the Barbados Privy Council, which is in effect a mercy committee, before their challenges, well, before their petitions before this committee were heard. It is a case that is in a long line of death penalty cases that has been, I don't want to say plaguing, but has been the subject of intense judicial discussion for decades. Any student of the law would tell you that in year one constitutional law, you'd spend about 60% of your time reading about death penalty cases. So in some ways, the Caribbean Constitution owes a lot to the effort to try to remove the death penalty. And the AG against Joseph and Boyce was the CCJ's and the Caribbean's first attempt to speak on the death penalty cases and the issue of the mandatory death penalty from a Caribbean perspective. And I think Rico is best suited to give a summation on the law of this case. But what I would say briefly is that in looking at the decision, Justice Hayton, in his 2007 lecture, shortly after the CCJ would have delivered Joseph and Boyce, emphasized that in coming to the decision in Joseph and Boyce, the CCJ attempted to derogate slightly from the Privy Council's approach of incrementalism and the slow development of constitutional structure. And he would have said that the court must be willing to develop the law in a way that respects human dignity and democratic values, right? And I'll now hand it over to my friend Rico, who could give you a pretty good synopsis of AG and Joseph and Boyce, since he is the tutor and the actional tutor, the course director of Commonwealth Caribbean Human Rights at the UEK Phil faculty, and will be far better placed to tell the court, tell the listeners about this case.
Yeah, so I think what is quite interesting about Joseph and Boyce, I mean, the CCJ had quite a lot to say, so much that we can't discuss all of it in this podcast alone. But the main thing you would remember from Joseph and Boyce is that the condemned men who were sentenced to death, in that case, they wanted to rely on a right in a treaty that was only ratified but not incorporated into the Barbadian legal system. Now, all of those listening who are from the Caribbean would know that Caribbean countries generally conform to dualism, right? So there's dualism and then there's monism. With monism, once a country ratifies an international human rights treaty, it automatically becomes part of that country's legal system, right? And then citizens of that country can benefit from the rights in that treaty once it has been signed and once your country has ratified to it, meaning consent to the obligations in that treaty. Now, dualism, which is what applies for Caribbean countries, is where you must not only ratify, but the country must actually incorporate it, meaning that it must go through the legislative process in Parliament for it to become part of the country's legal system and for it to actually be binding on the country. So it was quite interesting that both Boyce and Joseph, they wanted to rely on this procedural right in the treaty, but the treaty was only ratified, but it was not incorporated as one would expect it to be in a Caribbean country if if you want to rely on the right in that treaty. And the CCJ, interestingly, the CCJ looked at two previous cases where there were similar circumstances, Thomas and Batiste and Neville Lewis, where the condemned men in those cases also wanted to rely on rights in ratified but unincorporated treaties. Thomas and Batiste was from Trinidad, Neville Lewis was from Jamaica. And the CCJ criticized the Privy Council's approach in both Thomas and Batiste and Neville Lewis because, in their opinion, the Privy Council's approach was essentially dealing a severe blow to dualism. They were saying that essentially the approach that the Privy Council took in those cases went against what dualism is. But what's interesting about the CCJ's approach, two things really, is that the CCJ in this case is well known for transposing administrative law principles into constitutional law, perhaps for the first time in the Caribbean. And particularly the principle or doctrine of legitimate expectation. So what the CCJ did is that it transposed this administrative law doctrine of legitimate expectation into Caribbean constitutional law, in this case in Joseph and Boyce. And the CCJ essentially said that even though the treaty that Boyce and Joseph were relying on was only ratified but not incorporated, that these men had a legitimate expectation that they would be able to benefit from the procedural right in that treaty. And they said the legitimate expectation arose on a few bases. One, it was ratified. Two, the executive at that point in time, they had made positive assurances that they would abide by the obligations in the treaty. And then three, there was an established practice that previous condemned men would benefit from this particular right in the treaty, even though, again, the treaty was only ratified but not incorporated. And the CCJ said because of those three factors, they created a legitimate expectation for both Boyce and Joseph to benefit from the rights in the treaty. Now, as much as I love the CCJ, I have an issue with that reasoning because essentially they criticize the Privy Council approach, but they arrived at the same destination just using a different route. And the effect of it was also to deal a severe blow to dualism. Because strictly speaking, if you conform to dualism, whether or not there were positive assurances or an established practice, if the treaty is not incorporated, it cannot have any effect domestically. But the CCJ found a very clever way, while chastising the Privy Council, essentially, for arriving at the same destination that it arrived at. It found a very clever way, which I guess is more palatable than the Privy Council's approach, but still, it has the same effect, and you arrive at the same destination. So that was quite interesting about Joseph and Boyce, and I mean, I know that Alex is quite fond of the judgment from Justice Hayton, but I think most people prefer the judgment from Justice Witt. And it was a very powerful judgment for many reasons. One, Justice Witt, he he couldn't fathom why Caribbean countries were holding on to dualism for so long. You know, in the most diplomatic way in his judgment, he was essentially saying the doctrine of dualism is nonsensical, is utter poppycock. Because he was saying, how can a country on the international level make these assurances that it would abide by the obligations in this treaty, but then not want to give effect to these obligations domestically. He was saying it doesn't make any sense. So I think he described dualism as an old, molded, and creaky structure that is not suitable for the Caribbean terra firma or Caribbean soil. And anyone who knows Justice Witt, God rest his soul, I think he passed away, I think it was last year. Justice Witt was very well known for his judicial metaphors, and that was one of them. Another reason why Justice Witt's judgment was so powerful is because he's the one who gave us that very um unforgettable um dictum where he said the law cannot rule if it cannot protect. And in that, just to contextualize that statement, he was looking at the protection, the right to protection of the law. He was looking at the rule of law, which, as we know, is a fundamental constitutional principle. And he was saying the rule of law means that the law is to rule, but the law cannot rule if it does not protect. And if it does not protect persons like these same condemned persons, so he's saying in order for the law to be effective, we must make it effective as judges, essentially, right? And in interpreting the law and in interpreting the Constitution, we have to interpret in a way where the most marginalized or even the most minority of groups in Caribbean countries feel as though they are protected. And finally, I think there was something else that Justice Witt said in his judgment, but is not coming to mind right now. But essentially, those are some of the reasons why Justice Witt's judgment was so powerful in Joseph and Boyce. And even up to this day, his judgment is always cited in almost every single human rights case coming from the CCJ. And that's all I have to say.
Despite being a dissent, it has been famously cited. Perhaps maybe even more than the original case. It's maybe even more than the majority's decision. If somebody,
Exactly.
if somebody, um,
Exactly.
and I think as you go as we go through this podcast, you'll see that even though the arguments, the reasoning of Justice Witt in terms of dualism has not been used, that idea of rejecting established norms began to take root as the CCJ became more comfortable as a court. And I think it might be time to move to our second case.
Yep.
Perhaps one of the most famous or interesting cases out of the CCJ's jurisprudence. Maybe not as famous as AJ and Joseph and Boyce, but just as important.
Definitely not. I don't think any case, any human
Um,
rights case, Alex, could be as
well,
famous as Joseph and
well,
Boyce.
I mean, you would think so, but the Maya Leaders Alliance against the Attorney General of Belize, while not famous regionally, is a very important case internationally, as it is one of the few occasions in which a domestic court, a domestic Commonwealth court, had to deal frontally with the issue of customary land tenure for
Yes.
indigenous communities. And that is why I said it's probably one of the most famous and most important cases coming out of the CCJ's jurisprudence. Because while not heavily cited within the region, meaning the Caribbean islands, as a case of international importance, the CCJ's reasoning and rationale in the Maya Alliance case is quite important. So for some context on the Maya Alliance case, it dealt with a claim by the Maya peoples of the Toledo district that if essentially alleged that their rights to customary land tenure under the Belizean constitution had been violated by the government of Belize, who historically and even to this day continue to give out logging and drilling concessions to private land developers. And in affirming under sections 3D and section 17 of the Constitution, the CCJ affirmed that there was in fact customary land tenure to the indigenous Mayan communities. Right, so the Maya Alliance is an important case because while it was one thing for the CCJ to recognize that the Mayan persons had a right to their customary land based on their historical use and occupation, they took a step further and identified that the state of Belize had a positive obligation under the Belizean constitution to take affirmative steps to ensure that the Mayan people's right to their lands were protected. And while positive obligations under in constitutions is something that is not new and has existed under international law for quite some time, it is particularly important in the context of Caribbean constitutions and in terms of decolonizing justice, in the sense that the Mayan claim to their land was not rooted in the colonial system of land tenure. It was no deed, it did not come from the crown, but it was a reflection of the historical use and occupation of the Maya peoples. And it was the conferment of constitutional protection to a system of land tenure that predated a system of land tenure that would have come from the crown. And it, to me, is important because by imposing positive obligations on the state to now affirmatively protect Mayan land tenure, which, as a segue, the government of Belize has not done. They are still in the remedial negotiation. They are still in conciliation proceedings before the court. The court effectively recognized that the established norms of constitutionalism can extend beyond that which existed in the common law and in England, and protection of the Constitution was extended or allowed to venture into systems of land tenure and occupation that in some ways were established based on historical usage, in terms of this tribe or this group of peoples would have habitually hunted in this ground or habitually used this river. And using that historical evidence of occupation, rights and a right to property was established. And that is what Simeon McIntosh would call autochthonous jurisprudence, and allowing allowing the prevailing norms of a society to influence a constitutional interpretation and adjusting the established unwritten norms of your British Constitution to match the societal needs of your country. And I will now pass it over to Rico to share his thoughts.
Yes, thank you very much, Alex. As you said, this was a very interesting case coming from the CCJ's appellate jurisdiction. And I also agree with you that the highlight of the Mayan case is that the CCJ said that a state has positive obligations to protect the rights of its citizens. And in this case, it was the Mayan people. But I think what adds that autochthonous, to use your word, Caribbean flavor.
Not my word, Simeon McIntosh's word.
Simeon McIntosh's word, yes. My boy Simeon McIntosh, God bless his soul. What adds that autochthonous Caribbean flavor to the CCJ's reasoning is that the CCJ connected that to the right to protection of the law. And what our listeners and viewers would see throughout this entire episode is that the right to protection of the law features prominently in most of these cases that we're going to discuss. We just looked at it in Joseph and Boyce, and here again, we're looking at it in the Mayan case. So the CCJ actually said that this positive obligation to protect the rights of your citizens actually stems from the right to protection of the law, which is in the Constitution. And I think that is what gives it that Caribbean and autochthonous flavor. As a matter of fact, Alex, that particular reasoning and aspect of the Mayan case, speaking about positive obligations, is heavily cited across the entire Caribbean and even outside of the Caribbean. And why do I say that? Even the Privy Council itself, Alex, has relied on that reasoning from the CCJ. And I think perhaps the main case where they did that was the Commissioner of Prisons and CPSAD from Trinidad, right? Which dealt with having juveniles in certain institutions that were not suitable for them, right? So that's how powerful the reasoning and judgment in the Maya case is. So much so that the Privy Council, the other final court of appeal for other Caribbean countries, has relied on the CCJ's dicta in that case. In other cases, I know in other Trinidadian cases as well, it has been relied upon, even in some cases here in Barbados. So that part about positive obligations. Another highlight of the Mayan case, I would say, is, and I have to come back to this because this is perhaps one of the few areas where I don't necessarily support the CCJ's reasoning. I just touched on it in Joseph and Boyce, but the CCJ went even further. And I say not just further, but further away from the doctrine of dualism. Now, in the Mayan case, again, coming back to the right to protection of the law, the CCJ said that, and they relied on one of Lord Baham's sub-rules on the rule of law. Anyone who knows about, I know Alex would know about Lord Baham's book on the rule of law, because he reads it for leisure. And anyone who knows about Lord Bain would know that he propounded, or he put forward 8 sub-rules on the rule of law. And one of those sub-rules is that the rule of law requires you, or not requires you as an individual, but requires a state to comply with its international law commitments or obligations. And the CCJ relied on that sub-rule from Lord Bayham and they linked the right to protection of the law again to the rule of law, and said that the right to protection of the law and the rule of law, they both require a state to comply with their international law obligations, and that's whether or not those obligations are actually incorporated as dualism requires. So in protecting the customary property rights of the Mayan people in that case, the CCJ also look at all the different international human rights instruments, UN instruments, that actually recognize and protect the rights of Mayan people. Most of these international human rights instruments are not incorporated into Belize's legal system. But the CCJ said that the right to protection of the law not only imposes positive obligations on the state to protect their rights, but this right also requires the state to comply with these international law obligations in these instruments, even though they're not incorporated into Belize's legal system. And if that is not a significant departure or deviation from the doctrine of dualism, I don't know what is. So it's like the more cases we look at, we started with Joseph and Boyce, they were creeping away from dualism, and now they have crept even further away from dualism now in the case of the case of Maya Leaders Alliance. And there's one particular scholar who in her academic work, she refers to this phenomenon as creeping monism. And that is Melissa Waters. So the Maya Leaders Alliance case is definitely an important case within the context of Caribbean jurisprudence. And something else that the court also mentioned that stood out to me is that the court recognized that an award of damages is not an automatic entitlement once a constitutional right has been breached. So the court said, look, just because your there's some people who believe that once a constitutional right has been breached, you have an automatic entitlement to damages. The CCJ is saying, no, you don't have an automatic entitlement to damages because, again, whenever there's a breach of a constitutional right, any relief or redress that you get is discretionary, is at the discretion of the court. So the court is not obligated to give you damages, right? And that's something that the court highlighted in the Mayan case as well. And to add to that, because the remedies at the discretion of the court, do you remember, Alex, what remedy the Mayan people got in that case? It was a very unique remedy, very, very unique. And that again shows how unique the Caribbean Court of Justice is when it comes to human rights cases.
I think they were awarded 300,000 Belizean dollars in damages, if I remember.
Not necessarily damages. Not
but
necessarily
yeah,
damages.
not necessarily damages. Hmm,
You're almost there.
yeah,
300,000, but not necessarily in damages.
no, I truly can't remember, you know.
Yes, the Caribbean Court of Justice for our listeners and viewers. The Caribbean Court of Justice ordered the government of Belize to establish a trust fund in the sum of 300,000 Belizean dollars to go towards the protection of the customary land tenure and property rights of the Belizean people. And I don't think that before this case there was ever a constitutional remedy like that where the court actually ordered a government to establish a trust fund. Usually, you would get a declaration, you would get damages, whether they're compensatory or vindicatory. What else would you get? Sometimes you could get a mandatory order, but this, in my opinion, this takes the form of a mandatory order because it's mandating the government to establish this trust fund. So it is a form it is a form of what we would call a mandamus or mandatory order. But the fact that it was specifically a trust fund, that was the CCJ uniquely exercising its powers under what we call the redress clause in a Caribbean constitution to give the Mayan people this special and distinctive remedy. And that's all I have to say. So the Maya case is really a powerful case, really a powerful, and we see that today because the Mayan case, along with Joseph and Boyce, whenever the CCJ or any other court in the Caribbean, or like I said, the Privy Council, whenever any of these courts are looking at what the right to protection of the law entails, the Mayan case and Joseph and Boyce, those are two cases that you're going to see the court cite. Right? And
now,
it gets even more interesting. So I guess Alex, we could move on to the third case.
well,
And
well,
our
well,
viewers and
what
listeners will see
so,
how much more interesting these cases get.
yeah. So I think following from you, I know you wanted to move on to the good case, but just to contextualize how we've broken down the two cases so far, we have Boyce and the Maya case, which in my mind deals with the CCJ's attempt to not attack, but chip away at the dualist nature of Commonwealth Caribbean societies. And in the Maya Alliance case and in the Boyce case, we see that through legal machinations of their own accord, they have, in some novel way, brought international law principles into Caribbean constitutions, be it the legitimate expectation route in the AG and Joseph and Boyce, or in the Maya Alliance, extending protection of the law
They look
to
correct,
include
yes.
international obligations. And
So
now,
my problem with that, Alex, I just want to interject here. As much as I love the CCJ, as much as and I know you're laughing because you know what I'm about to say. As
yeah,
much as I love the CCJ, my question, and I always pose this question to my particular students when I'm looking at this particular topic, is this something that a court should be doing? I have tremendous respect for the CCJ, but if it is that we're supposed to deviate from dualism, should this be left to a court or to Parliament?
um, well, it's an interesting question and probably another podcast, but to speak
Yes.
briefly on it, I think I think it would be a bit foolish to pretend that there was no influence of international instruments in the preparation and drafting
So
of
I'm
the
not
Caribbean
disputing that.
Constitution.
I
Right,
am not
I
disputing
know,
that.
but
But
so
if
when I
Alex, just hear me out, my brother. Hear me out. When we look at the purpose of dualism, now one of
yeah,
the purposes of dualism was to keep the doctrine of the separation of powers intact. And Justice
mhm.
Pollard, God rest his soul, another um former CCJ judge who has departed this life, he he made this statement in Joseph and Boyce. If you could go back to Joseph and Boyce for a few seconds, he acknowledged that one of the purposes of dualism, the doctrine of dualism, was to keep the separation of powers principle intact. Why? Because while the executive branch of government ratifies the treaty at the international level, the legislative branch of government or parliament was supposed to incorporate it into the domestic legal system. Hence, those separations of powers, right?
Yeah, so, but
Now,
as
if
I
it
was
is,
about to
now
say,
hear me
yeah,
out, hear me out, hear me out. If it is that one of the reasons for dualism is to make sure that separation of powers is safeguarded, shouldn't any deviation from dualism and any embrace of this monist element we're seeing, shouldn't that be made by Parliament and not the judiciary? So I love
but,
again, I love the
but, but,
CCJ, but I'm not too
but you
sure
see,
that they were acting within their boundaries there.
right. This is where we are at an impasse, and I think the listeners should know that Rico and I have many impasses.
We
Um,
always do.
but I would understand your your reasoning if it were the case that the CCJ were wholesale implementing these treaties.
But
Um,
that is the effect of the Mayan case. To
not
say
the,
that
it's
the
not
right
the,
to protection of the law requires a state to comply with its international obligations, and this is whether or not they're incorporated, that is the effect. The effect is a wholesale incorporation. That is the effect
no,
of it.
it's not it is the right to comply with your international obligations, yes, but but to the extent that this means that you have to remember, if you read a treaty, there are principles espoused in the treaty, and there are substantive obligations that the treaty requires, right?
Yes.
Right. And I tend to find favor with the CCJ's logic and reasoning that there has to be some merit to a country deciding to sign and ratify a treaty. It is an executive act, right?
Mm-hmm.
Even though it's not parliament or that it has incorporated this treaty, the executive represents the elected arm of parliament. The executive is appointed by the ruling government, right? They take action in the
Yes,
interest of the elected arm, right? So there's
who makes the
right, but
laws
who makes
for
laws, right?
the good
I
governance
know,
of the
and
country?
at no point has the CCJ said, I know you're gonna hit me with, but listen, comply. But
Exactly.
at no point has the CCJ said that you must now wholesale incorporate this treaty
But
into your.
of course, but Alex, of course, they're not going to say that.
No,
They're
but
not going to be that. They're not going to be that overt
take
with
for
it. But
example,
but that
yeah,
is the effect. That
no,
effectively, that is what they're saying
it's
without
not
using those words.
no, it's not effectively. It isn't in the sense that it is. In my mind, I view it simply as the CCJ giving an element of weight to an executive act and not pretending or hiding behind the idea that for any executive act to have merit or weight, it needs to go through Parliament and be codified into law. And as a matter of principle, I find merit in the logic that
Okay,
if
fair
an
enough. I
elected
mean,
if an elected official um, on government advice signs and ratifies a treaty, um, some level of merit or some level of benefit should be accorded to the citizenry as a result of that treaty. And if you look at treaties in their entirety, there are a host of obligations that flow under them that require incorporation, be it the establishment of certain bodies, the adjustment to certain reporting mechanisms, like in ESCAZU, for example, requires ESCAZU is a access to information treaty, requires certain information to be reported in terms of environmental decisions. Um, I don't see a problem with a court requiring that the principles or that certain key elements of a treaty be reflected or be available to persons once a state has decided that we as the executive agree to this.
But what I would
Living-
say, in response to your assertion is,
Yeah.
take Guyana for example. When you go to Article 154A of Guyana's Constitution, you know what it says? That the citizens of Guyana can benefit from any of the international human rights treaties outlined in I think it is the fourth schedule attached to the Constitution. And when you go to that schedule, you will see treaties like the International Covenant on Civil and Political Rights. I think you may even see the United Nations Convention on the Rights of the Child, etc., and many other international human rights treaties. That was a conscious decision on the Parliament of Guyana to reflect that any international human rights treaty in that schedule, a citizen of Guyana can benefit from. Parliament, not the judiciary. So again, is this something that should be left to the judiciary? Is a court, when is saying something like the rule of law and the right to protection of the law requires a state to comply with its international obligations, is that something a court should be doing or even saying, Mr. Ramdas?
As you are well aware, Mr. Yearwood, Commonwealth Caribbean constitutions are sui generis. And in that
Mr.
regard,
Ramdas, before before we go down this road and the episode never ends, I'm sure that our viewers and listeners wouldn't want this to end, but it has to end. But before you go down that road, I'm just going to say we will agree to disagree because we will never end this debate if you go down this road about sui generis and living instrument principle. No.
Well, just to close my point off, because they are deserving of their own interpretation, and parliaments have never made an effort to rein in the courts in ascribing their own interpretations and understanding to the Caribbean constitutions. There is merit in saying that the court, including the CCJ, can read certain things into the Constitution. And that might be a perfect time to
segue into
the topic for our next episode, which would be the cases of Neve and Severin against the Queen, McEwen and the AG, and Belize International Services against the AG of Belize, where we now see the courts separate and apart from their chipping away at the idea of dualism, now dealing frontally with how do we interpret Commonwealth Caribbean constitutions.
And particularly, Mr. Ramdas, how do we utilize, or rather, to what extent should we utilize fundamental underlying constitutional principles like the separation of powers and the rule of law? Is the separation of powers, is the rule of law, are these principles supra-constitutional principles, meaning that they're above the written constitutional text itself, or are they intra-constitutional principles, meaning that they're part and parcel of the Constitution? A very interesting discussion coming next week for you guys when we discuss part 2 of this particular topic, the CCJ's contribution to the development of Caribbean constitutional law.
Or as we have titled it, Decolonizing Justice.
Yes. So thank you all for joining us, and we look forward to discussing the 3 other cases with you next week. So until next time, guys, we bid you adieu. Thanks for joining us at the Public Law Parlour.
Right. Farewell, guys.